welcome to our second in our CLE webinar series on commercial tobacco regulation in Minnesota. Today's topic is the legal landscape of flavored commercial tobacco products. So before we dive in, I want to give introduction to myself and our presenters. I am Rachel Callanan. I'm the lead senior staff attorney at Public Health Law Center, and I lead the center's work on commercial tobacco technical assistance specifically for our Minnesota project. Willow Anderson is a staff attorney at the center working on our Minnesota team. She provides legal technical assistance nationally to support tobacco control policy. As a part of the center's FDA project, she works with state, tribal, and national public health experts to inform and encourage the FDA to enact sound and equitable policies for the protection of public health. Willow is a former assistant attorney general, having tried cases in almost every county in Minnesota. In private practice, she represented injury railway workers in litigation that resulted in the release of industry documents covering up wrongful deaths and injuries. Her international work has included trial skills training, interrogation, and persuasive advocacy in Botswana, Russia, and the Republic of Georgia and Turkey. She is a Minnesota Supreme Court certified mediator and qualified neutral. Marissa Katz, our other presenter, is a senior staff attorney at the center. She provides legal technical assistance on commercial tobacco control issues to public health organizations, legal professionals, and advocates in Minnesota and throughout the United States. Prior to joining the center, Marissa was a partner at a Minneapolis law firm representing clients primarily in complex and class action litigation on behalf of consumers and employees in federal and state courts nationwide. Earlier in her career, Marissa was a staff attorney at Southeast Louisiana Legal Services, where she provided civil legal aid, advocacy, community education to low-income individuals in New Orleans and Southeast Louisiana. So the Public Health Law Center is a nonprofit organization. We provide legal technical assistance on a range of public health topics. This webinar series has been funded with support from the Minnesota Department of Health through their Office of Statewide Health Improvement Initiatives. The center is located at Mitchell-Hamlin School of Law in St. Paul, Minnesota. We acknowledge our presence in the tribal and treaty homelands of the Dakota Oyote since time immemorial. These lands are home to the Sisseton, Wahpeton, Mdewakanton, and Wapakute Dakota peoples. The center's land acknowledgement was developed by the Native American Law and Sovereignty Institute at Mitchell-Hamlin School of Law and is being used with permission. For more information on the indigenous peoples in these tribal lands, we encourage you to visit the Health and Equity page on our website. In our discussion of commercial tobacco regulation today, we want to acknowledge the difference between traditional and commercial tobacco. Throughout this presentation, we will make a distinction when we refer to the harmful impacts of tobacco. We are talking specifically about industrial scale commercial tobacco products and not talking about traditional tobacco as it is still used for religious, medicinal, and ceremonial practices. To learn more about the important distinction, here are two resources linked on this page for more background. So at the Public Health Law Center, we offer free legal technical assistance to communities, public health advocates, and other partners. We also publish on important issues pertaining to commercial tobacco control. If you visit our website, you will see many publications there. And we offer trainings and webinars like this. We do not offer direct legal representation, nor do we lobby. Our commercial tobacco legal technical assistance in Minnesota communities is funded through a grant from the Minnesota Department of Health. Health equity is at the center of all of our work. In the context of our commercial tobacco work, this means we are mindful of the equity implications of policies, including harmful targeting by the tobacco industry and the unintended consequences of certain policies, such as enforcement measures and penalties. Today, the presenters will be talking about how the industry has effectively used marketing as flavored tobacco products to target certain communities, resulting in significant and long-lasting harms to those communities. So today the presenters will provide you a background on what these flavored products look like, what they are, and how the industry continues to use flavors to addict new customers. Then you'll hear an overview of federal regulations around flavored products, including the FDA's actions and inactions on this front. Next, you'll learn about the national landscape of flavored product regulation before shifting into a focus on the status of flavored product regulation, specifically in Minnesota. And finally, you'll learn about the legal challenges that have been raised for flavored tobacco regulation at the state and local levels. With that, I will hand it over to Marissa Katz.
Great. Thank you so much, Rachel, and good afternoon, everyone. So for the uninitiated, let's just kind of do a quick overview of what flavored tobacco products are and why do they even exist. When we talk about flavored tobacco products, we're referring to the universe of products out there that are produced, manufactured, and distributed by the tobacco industry. And these flavored products include primarily flavored e-cigarettes, menthols, flavored cigars, flavored smokeless tobacco products like snus, and the latest product that's unfortunately increasing in popularity of late are synthetic oral nicotine pouches, products like Zyn. The tobacco industry has sold flavored tobacco products in the market for many decades, and the reason for that is simple. Flavored tobacco products have and continue to be very profitable revenue stream for them. And this is because flavored products mask the harshness of tobacco and improve the taste, which in turn makes it much easier to initiate new smokers. And not to sound too grim, but bringing in new smokers and getting them addicted to these products is essential for an industry that, in order to maintain its profits, must replace lifetime smokers who have died of cancer and other diseases that we've known for quite some time are linked to tobacco product use. The tobacco industry also has a long track record of targeting certain demographics with flavored tobacco products in particular. Research has shown that flavored products increase initiation among all populations, but especially with kids. Research also has shown that most smokers try cigarettes or e-cigarettes before turning 18, and that most teens start with flavored tobacco products. As for menthol in particular, and I'll get into the FDA's menthol rule momentarily, but it's important to have a bit of background on menthol products. First, what does menthol even do? Menthol's cooling properties, like other flavored products, mask the harshness of tobacco smoke and the irritation that results from nicotine use. Evidence has shown that menthol enhances the addictiveness of cigarettes, both by increasing the likelihood of nicotine addiction in youth and by making quitting among adult smokers more difficult. It's also important to note that the tobacco industry has specifically targeted its sales of menthol cigarettes to historically marginalized populations. As a result, menthols are used at a disproportionately higher rate by racial and ethnic minority populations, including African American smokers, of whom 85% smoke menthols. Of Latino smokers, 46.9% use menthol products. And Asian Americans, of those smokers, 38% use menthol, compared to white smokers, in which under 30% use menthol. With other groups, approximately 71% of LGBTQ smokers use menthol cigarettes, and at least half of all teen smokers use menthol products, including 70% of African American teens, and more than 50% of teens of Hispanic or Latino descent. Menthol product use is also prevalent among non-minority youth, as well as with low-income populations. So because of industry targeting, evidence has shown that tobacco-related health disparities, including chronic disease and death, are then exacerbated among these populations. Also, as we know most recently from the Centers for Disease Control and Prevention's 2023 National Youth Tobacco Survey, e-cigarette use among youth remains at very high levels. About 1 in 10 middle and high school students said they recently used a tobacco product, which translates into 2.8 million kids nationwide. And of those, more than 2.1 million youth currently use e-cigarettes. Of those who use e-cigarettes, 90% of students who vape reported using flavored products with fruit and candy at the top of that list. The most popular brands among youth are ones you've seen on market shelves, including well-known brands such as Elf Bar and Jewel, to name a couple. Some of these flavored products are clearly designed to attract youth with flavors like watermelon, blue cotton candy, dragon fruit, banana berry, root beer float, and so on. Looking at what's happening in Minnesota specifically, the Minnesota Student Survey data demonstrate the rise in vaping among students from 2016 to 2019, when e-cigarettes really gained a firm foothold in the market. This increase in youth vaping erased 15 years of progress, lowering youth commercial tobacco use in our state. Now we're seeing a reduction in youth vaping since the high point in 2019, due in part to increasing the minimum legal sales age from 18 to 21 back in 2020. But the persistence of the tobacco industry to addict young people has not abated, particularly with respect to the use of flavored products. And looking at flavored e-cigarettes in particular, you can see from the Minnesota Youth Tobacco Survey in 2020, this graph shows that Minnesota youth who vape are mostly using fruit-flavored vapes, with 3/4 of teen use being with fruit flavors. Mint is the second most popular at 48%, and a close third is candy or dessert flavors. So the trends in Minnesota largely mirror national trends in that youth are drawn to fruit, mint, candy flavors, and more than any other type. And it's important to also know that not only are flavored products popular, but they are packed with nicotine. You can see how popular brands like the Loon flavored vapes shown on this slide are so incredibly addictive. And I want to thank Elise Less at the Tobacco Free Alliance for actually doing the math to illustrate this very compelling comparison here between nicotine content levels in e-cigarettes versus combustible cigarettes. The big picture here is that disposable vape products, which contain higher nicotine salt levels than other vapes, have been available the past few years and continue to flood the market. How long does it take to go through one of these disposable vapes? That depends on the user, of course. It's much different than how someone smokes a cigarette, because those who vape usually take hits all day throughout the day, which will then amount to a lot more than the number of combustible cigarettes smoked in a given day. But generally, you'll get about 100 puffs for every milliliter of liquid. So a 2 milliliter disposable vape pen will have about 200 puffs, which can last anywhere from a couple of days to a couple of weeks, depending on how often you use it. Of course, nicotine is highly addictive. So on average, these devices tend to be finished in only a matter of days. So all this begs the question, how are these and other flavored products still available on the market, especially given how harmful and very, very addictive they are? Let's start with what's happened at the federal level. Congress passed the Family Smoking Prevention and Tobacco Control Act, more commonly known as the Tobacco Control Act, or the TCA, which was signed into law by President Obama back in 2009. This landmark law prohibited cigarettes from containing any characterizing flavor, including candy, fruit, and alcohol flavors. This law is the reason why you don't see watermelon flavored Marlboros or cherry flavored Camel Lights in the marketplace. However, thanks to the tobacco industry lobby and the huge role menthol plays in their product sales, the law exempted both tobacco and menthol flavors, and the law did not extend to e-cigarettes and other non-cigarette tobacco products. Now, to the extent there's any silver lining to the menthol exemption, which there really isn't, and you'll see why in a moment, the TCA, in acknowledging the public health problem left unaddressed by this exemption, created and directed the Tobacco Products Scientific Advisory Committee to study, quote, the issue of the impact of use of menthol in cigarettes on the public health, including such use among children, African Americans, Hispanics, and other racial and ethnic minorities. The advisory committee, by the way, continues to advise the FDA commissioner to discharge responsibilities as they relate to tobacco product regulation. For instance, they'll review and evaluate safety, dependence, and health issues relating to tobacco products and provide the appropriate advice, information, or recommendations to the FDA commissioner. But after this initial study, when the law first passed, the advisory committee issued a report documenting its findings in July of 2011, which concluded that removing menthol cigarettes from the marketplace would benefit public health. At this point, rather than act promptly to protect public health by prohibiting menthol as a characterizing flavor, the FDA instead announced it would conduct its own independent study on menthol cigarettes. And in July of 2013, the FDA released a report that essentially confirmed the committee's findings and conclusions back in 2011, which is that menthol cigarettes not only pose a public health risk, but also that that public health risk exceeds the risk posed by non-menthol cigarettes. So the FDA then issued a non-binding advance notice of proposed rulemaking, which included accepting public comments through November of 2013. During that time, 174,000 public comments were recorded, and that was in addition to the already thousands of pages of menthol research gathered by the FDA, the TPSAC, and public health groups, but no rule was implemented despite these reports. Moving on to 2016, the FDA did issue a regulation asserting jurisdiction over non-cigarette tobacco products. And this regulation is more commonly known as the deeming rule. And it was an important change in the regulatory landscape because it meant the FDA would now oversee the regulation of e-cigarettes. So a very important development. However, the FDA's draft version of the deeming rule did extend the TCA's flavor restriction to non-cigarette products, though it did retain the menthol exemption. But the White House Office of Management and Budget at the time ended up removing the flavor provision right before the deeming rule was finalized and issued. As a result, there are currently no federal prohibitions for flavored e-cigarette products and no prohibitions on menthol for either cigarettes or e-cigarettes. And then on July 28th, 2017, the FDA announces a comprehensive regulatory plan for tobacco products that is intended to prioritize restrictions on flavors that are attractive to youth, including menthol. This plan also intended to establish a cohesive agency-wide approach to nicotine, but the FDA in actuality has not even to date taken any substantive regulatory action on flavored tobacco products since that announcement was made. And as we know in the meantime, e-cigarette use among youth continues to skyrocket, and menthol cigarettes continue to be widely sold across the country. Now, it's against this backdrop of the lack of regulatory action on the part of the FDA that citizen petitions began to be filed by public health organizations and advocacy groups, all trying to push the federal government into action. And under the Administrative Procedures Act, federal agencies must give interested parties the right to petition for the issuance, amendment, or repeal of any federal law. This is known as a citizen petition or a rulemaking petition. And the APA petition mechanism is, in theory, supposed to be an efficient means for an individual or other stakeholder to call on a federal agency to take particular action. And in this case, the citizen petition action sought is for the FDA to issue two rules, the menthol rule and the cigar rule. The menthol and cigar rules will close the major loophole left open since the TCA was passed in 2009, and efforts to get the FDA to prohibit the sale of menthol products has been in the works since at least 2013, and I'll remark on that in a moment. But the rules are intended to finally designate menthol as a prohibited characterizing flavor, as well as ban all flavored cigar and cigarillo products. And this slide shows the cigarette part of the FDA rule, and it's intended to prohibit menthol as a characterizing flavor in cigarettes, which of course is something public health advocates have been pushing for years for the FDA to act upon. And by banning menthol as a characterizing flavor, the FDA will have a significant impact on public health by reducing the use and uptake by young people, and in particular by African Americans and other historically marginalized groups. Again, we've been waiting for this rule for a decade now, more than a decade, and having it in place will be critical in decreasing the disease and death associated with these products. The rule is sorely needed, of course, but there are a few problematic loopholes or weaknesses in the rule, such as the rule fails to define what characterizing flavor means, and also leaves open the possibility of exempting certain cigarettes, such as heated tobacco or VLNs, which are very low nicotine content cigarettes, which, if those exemptions go through, it will allow the industry, of course, to exploit that loophole and continue to keep these products on market shelves. Similarly, the cigar part of the FDA rule also has worrying statistics for young people with respect to flavored cigars. Youth are also initiated into smoking through the use of flavored cigars because that's an easy entryway to tobacco product use. They're enticed by the colors and packaging of flavored cigars, as well as the typically low price associated with these products. The proposed ban would drastically reduce initiation and prevent the tens of thousands of young people from becoming lifelong smokers. The potential weaknesses in the rules, just like the menthol rule, involve similar failures to define characterizing flavor, not addressing flavor additives, opening up exemptions for certain cigars, and also leaving out other products such as water pipes and pipe tobacco. But overall, public health advocates also very much want to see FDA action on flavored cigars. But turning back to citizen petitions for just a moment, this slide illustrates a rough chronology of attempts by interested public health organizations that have spent more than a decade trying to get the FDA to act on both the menthol and cigar rules. Starting on April 12th of 2013, so a while ago, the Public Health Law Center and 18 of its partners filed a citizen petition calling on the FDA to add menthol to the list of prohibited characterizing flavors. The citizen petition included extensive information on the impacts of menthol in cigarettes, including scientific evidence gathered by the Tobacco Products Scientific Advisory Committee, which had been essentially ignored for many years. And in response to that lack of action or even attention at all to this issue, in June of 2020, the African American Tobacco Control Leadership Council and Action on Smoking and Health filed a lawsuit seeking to compel the FDA to act on, at that time, the 7-year-old citizen petition filed by the Public Health Law Center. And in January of 2021, weeks before the FDA's promise to respond to the 2013 petition, the Public Health Law Center, along with 22 other public health partners, supplemented the 2013 petition with 78 additional studies supporting a menthol ban for the protection of public health. So the FDA announced in April of 2021 that it would grant the petition and remove menthol from cigarettes and all flavors from cigars and cigarillos. However, the FDA has still not committed to a specific deadline as to when that will happen. The FDA stated it has sent the menthol and cigar rules to the White House Office of Management and Budget for review, which is the last regulatory step before the FDA issues its final rules. But it's been almost 2 years since the public comment period ended on these rules, and of course, almost 15 years of waiting for the agency to act on this issue. Most recently, the African American Tobacco Control Leadership Council filed yet another citizen petition just a few weeks ago on April 2nd, so we'll see how this plays out. So where does this leave us? Given the very long regulatory delays and significant public health threat that flavored tobacco products pose, many local and state governments have not waited for the FDA to act and have used their authority to regulate the sale, pricing, marketing, and advertising of these products. Importantly, the TCA does preserve state and local governments' authority to enact laws prohibiting the sale of tobacco products. So states do have the authority to enact their own laws and regulations related to product sales. However, states cannot regulate what's known as tobacco product standards, meaning they can't regulate the characteristics of a tobacco product. And it's the tobacco product standards provision in the law that's often argued by the industry when challenging state or local sales prohibitions on flavored products. But courts have rejected these arguments since flavor prohibitions are directly related to the sales prohibitions preservation clause in the TCA. And it's not just flavor prohibitions. The case law is pretty settled in that states and localities do have the authority to regulate where and how products are sold in their jurisdictions, including regulating a range of tobacco control areas pertaining to public use, clean indoor air laws, tobacco retail licensing laws, zoning, and the like. So what are states and municipalities out there that do prohibit or otherwise restrict flavored tobacco products? And this slide provides a link to 2 resources. The first is the Public Health Law Center's list of jurisdictions that is updated annually. The 2024 edition is due out very soon. And what's nice about this resource is that it's organized into different charts based on the nature of the flavored product restrictions, as well as by state, capturing the variations in flavor restrictions. So in the first chart, jurisdictions are organized based on how they address specific public health best practices in their ordinances, like, for instance, covering the entire jurisdiction, prohibiting menthol, restricting flavors in all tobacco products, and not including any exemptions. There are also links provided in this resource to each jurisdiction's laws and summarizes relevant legal challenges. The second resource on the right is one compiled by the Campaign for Tobacco-Free Kids. It also provides an up-to-date list of state and localities around the country that have enacted various flavored tobacco product restrictions. But to give you a general overview of the state and local landscape around the country, in 2018, San Francisco became the first major US city to end the sale of all flavored tobacco products when voters overwhelmingly upheld the city's law against an industry-driven ballot initiative. In November of 2019, Massachusetts became the first state to pass a law prohibiting the sale of flavored tobacco products, including flavored e-cigarettes and menthol cigarettes. In November of 2022, California voters upheld the state's law prohibiting the sale of flavored products when it faced an industry-driven ballot challenge. New York, New Jersey, and Rhode Island have also ended the sale of flavored e-cigarettes. And Maryland and Utah restrict the sale of some flavored e-cigarettes. At the local level, more than 375 municipalities have enacted ordinances restricting the sale of flavored tobacco products. Some large city examples include Chicago, Illinois, and Boulder, Colorado. So clearly, there's movement going on here at the state and especially at the local level in which the public health threat of these products is well known and action has been taken. Of course, the industry is not sitting idly by without a fight. And in many of these jurisdictions, the tobacco industry has filed multiple lawsuits challenging these prohibitions, arguing a variety of legal claims. Willow will speak in more detail about those specific legal challenges in a bit, but the takeaway here is that courts across the country have generally upheld laws enacted to end the sale of flavored products, including in Massachusetts and California, as well as at the local level, with the city of Edina's ordinance being recently upheld as an example that's close to home. So with the mention of the local example of Edina, Minnesota, I will now turn things over to my colleague, Willow Anderson, who will go over what's happening in our state with respect to regulation of flavored products.
Thank you for that context, Marissa, and hello, everyone. First, I'm going to address Minnesota specifically, and then look more closely at the causes of action that we've seen the tobacco industry lodge. In a nutshell, just know that in Minnesota, 30 jurisdictions have implemented some restrictions on flavored tobacco. These ordinances are all actively in play, and there's been no successful legal challenge. Let's take a closer look. Here we have a great interactive map created by Minnesota Association of Non-Smokers that you can access on their website. You can click on it and see if your community restricts flavors, and if so, how. We know that municipalities that have enacted these restrictions are seeing a reduction in youth initiation. In addition to local bans, there has been strong momentum for a statewide ban. House File 2177 would have prohibited the sale of commercial nicotine products that taste or smell different from tobacco. This includes products smelling or tasting like chocolate, cocoa, fruit, honey, menthol, mint, vanilla, wintergreen, or any candy, dessert, alcoholic beverage, herb, or spice. As of last week, unfortunately, we learned that the bill didn't make it into an omnibus bill, so it won't be passed this year. But if it had, a business could be fined $1,000 for the first infraction and $5,000 in subsequent instances for selling flavored commercial tobacco products. So there's a level set of where we are locally and statewide, but legally, what has happened to these ordinances? Of the 30 local flavor ordinances, there have been 4 legal cases in Minnesota. In these 3 cases on the screen, Arden Hills, Prior Lake, and Moorhead, it was a tobacco or vape shop that was suing, and their causes of action in each case were the same. The shops argued, number 1, equal protection violation because there's no rational basis for adopting the ordinance because it's not related to a governmental interest. 2, the ordinance is void for vagueness because the definition of flavored products in the ordinance relies on a subjective consumer standard. 3, the ordinance is singled out allegedly and punishes the shop and therefore constitutes an unlawful bill of attainder. And then the fourth legal argument that the shops made is that the ordinance constitutes an unconstitutional regulatory taking by making unlawful the sale of most of the shop's products. None of these shops were able to mount successful legal challenges. Their claims didn't even withstand an initial review by the courts. This suggests that their legal arguments were weak, and also that the city attorneys handling the cases were skillful. In any case, given the early resolutions without substantive rulings, these particular lawsuits don't give us any case law. And while businesses deserve fair treatment, litigation does need to be grounded in sound legal principles, and these shops were not able to do that. R.J. Reynolds versus City of Edina is more complicated. Here are the facts of RJR versus City of Edina. Edina passed an ordinance on June 16, 2020, banning the sale of all flavored products. In federal court, RJR argued that Edina's law was expressly and impliedly preempted by the Federal Tobacco Control Act. Yet the Eighth Circuit found that the ordinance did not conflict with federal law, emphasizing that local regulations on sales are not precluded by the Tobacco Control Act in Minnesota. And I repeat, local regulations on sales are not precluded by the Tobacco Control Act. The lower court's reasoning was a little different than other circuits, but it aligned with the principle that localities can protect public health through sales restrictions. On appeal, the Eighth Circuit upheld the decision. The Public Health Law Center, along with 23 other public health organizations, supported Edina with an amicus brief. And this would be a good time to add that the Public Health Law Center offers free legal technical assistance to cities or other municipalities facing these kinds of lawsuits, providing support but not direct representation. The other big recent case here in Minnesota, State of Minnesota versus Juul and Altria, its parent company. The complaint was filed in 2021 in Hennepin County on behalf of the state of Minnesota, alleging that Juul had committed consumer fraud, deceptive trade practices, false statements in advertisement, public nuisance, negligence, and negligence per se. I was able to attend some of that trial, where one of the most remarkable things I heard was right out of the gate. Some of you on this call were there with me and heard it for yourself. In opening statements, the attorney for Juul argued that they shouldn't be held liable because the company's primary goal was to switch adult combustible smokers to vapes, and that the youth who picked up this addiction for the first time were leakage. That was the word he used, leakage, sort of like the term breakage in business. That was his defense, that the youth were leakage. And as if that wasn't enough, the other part of their defense was that Big Tobacco had already paid enough money through the 1998 Master Settlement Agreement, and that the Minnesota legislature was to blame in the way that they spent those funds. Juul and Altria argued that the Minnesota legislature could have done more and should have done more to protect the youth from their products. The trial was about 2 weeks long, and after closing arguments, the parties reached an out-of-court settlement. And I should note that the state of Minnesota was the only entity to bring Juul to trial. Minnesota's $60.5 million settlement with Juul and Altria was the largest per capita of the 48 states and territories that have settled. Congratulations. And as a part of the deal, Juul agreed not to sell flavored products in Minnesota. But restricting only Juul flavored products isn't enough, showing why a comprehensive approach with state and local units of government is still needed. Moving now into the legal nitty-gritty of this CLE. Warning, this is going to feel a little like a trip back to your first year of constitutional law. And for non-lawyers on the call, it'll give you a taste of how complex this has gotten. The legal challenges brought by the Big Tobacco are substantial. They cover a wide range of constitutional issues. Specifically, we're talking about preemption, Commerce Clause, equal protection, the First Amendment, vagueness and overbreadth, due process, and the Takings Clause. However, when it comes to flavored tobacco products, the industry's legal arguments haven't flown. Personally, to me, this is what makes this work so interesting, the interplay of legal doctrines and public health policy. Now, let's explore the constitutional challenges. Preemption in the context of flavored tobacco bans refers to higher level government entities, state or federal, restricting lower level jurisdictions, cities or counties, from enacting or enforcing their own stronger regulations on the sale or distribution of flavored tobacco products. One of the more common legal arguments Big Tobacco makes is that states and municipalities are preempted from acting because of the commercial or the Federal Tobacco Control Act. In Minnesota, we're fortunate because we don't have preemption regarding flavored tobacco bans, meaning local governments here have the authority to enact their own regulations on the sale of flavored tobacco products without being overridden by state law. And this allows cities and counties in Minnesota to implement stricter controls on flavored tobacco than those set by the state. And when we talk about our Commerce Clause, in summary, Big Tobacco has claimed unsuccessfully that flavored bans violate the Commerce Clause by discriminating against interstate business, unduly burdening interstate trade, conflicting with federal law, and overstepping the boundaries of state power by regulating both interstate and intrastate commerce. However, here again, courts must weigh these constitutional concerns against public health interests for bans, and public health has won. First Amendment challenges to flavored tobacco bans often revolve around the argument that such bans infringe upon the commercial speech rights of tobacco companies. And here's how the challenges are typically framed as applied to flavored tobacco bans. Tobacco companies have argued that selling flavored tobacco products is a lawful activity and that their marketing communications are not misleading and thus deserve First Amendment protection. Tobacco companies have also challenged the strength or validity of the governmental public health interests and argue that the ban is not the least restrictive means to achieve it. They've argued that flavored tobacco bans don't directly advance the goal of reducing tobacco use among minors, suggesting that there are other means that could be equally or more effective. And they've argued that a complete ban on flavored tobacco is more extensive than necessary to protect public health, infringing upon their commercial rights more than they're justified by the governmental interest. In summary, these First Amendment challenges hinge on the balance between the governmental interest in public health and the tobacco's right to engage in commercial speech. Courts weigh these health benefits versus the bans on the commercial speech rights of tobacco companies, and here again, public health has won. Equal protection challenges to flavored tobacco bans argue that these laws unfairly discriminate between different groups or types of businesses without a sufficient governmental reason. The Equal Protection Clause, part of the 14th Amendment to the U.S. Constitution, requires that states treat individuals in similar situations similarly. Here's how equal protection arguments have been structured in the context of flavored bans. The claim starts by identifying how the ban differentiates between entities or products. For example, if a ban targets only certain types of flavored tobacco products, like vaping products, but not others, like menthol cigarettes, they've argued that unequal treatment under the law. The key legal test for most economic regulations under equal protection challenges is whether the law has a rational basis related to governmental purpose. The tobacco companies have argued that there's no rational basis for distinguishing between flavored product bans and those allowed, suggesting that the ban is arbitrary or capricious. They've claimed unsuccessfully that all tobacco products pose health risks, and thus distinguishing between them on the basis of flavor does not advance the governmental interest in public health. In summary, an equal protection challenge to a flavored tobacco ban would likely focus on whether the law unfairly discriminates between different types of tobacco products or businesses without a sufficient justification. Vagueness and overbreadth are two common constitutional challenges that have been raised against flavored tobacco bans. With vagueness, tobacco companies have argued that terms used in flavor ban legislation, like characterizing flavor, are unconstitutionally vague. They contend that these terms don't provide clear notice of what's prohibited, leading to arbitrary enforcement. For example, in the case of R.J. Reynolds versus the County of Los Angeles from 2020, the company argued that the term characterizing flavor was subjective and unclear, as it could potentially encompass any perceivable flavor, even if not intentionally added. However, the court ultimately rejected this argument, finding that the term was sufficiently clear in the context of tobacco regulations. Tobacco companies have also argued that the bans are unconstitutionally overbroad, as they prohibit more conduct than necessary to achieve the government's interest in reducing youth tobacco use. They argue that the bans restrict adult access to flavored products, and they go beyond what's needed to address the problem of youth appeal. In the case of National Association of Tobacco Outlets versus the City of Providence, Rhode Island in 2012, tobacco retailers argued that the city's ban on flavored tobacco products was overbroad because it prohibited the sale of products to adults, not just minors. However, the court found that the ban was appropriately tailored to address the government's interest in reducing youth tobacco use. Here are a few relevant cases and examples alleged to due process violations. Remember, with due process, there's the substantive due process and the procedural due process. As it pertains to substantive due process, we look again at RJR versus the County of Los Angeles, the 2020 case. And here the company argued that the ordinance violated substantive due process by interfering with adult consumers' rights to purchase legal products. However, the court rejected this argument, stating that the ordinance was rationally related to the legitimate government interest of reducing youth tobacco use. That was the similar case that was brought in the National Association of Tobacco Outlets versus the City of Providence in 2012. And the City of New York saw this claim in U.S. smokeless tobacco manufacturing versus the City of New York in 2010. In all cases, the court sided with public health. And I do want to also call one other case to your attention. This is a procedural due process case out of Florida from 2013, Indigo Room versus City of Fort Myers. Although not directly related to flavored tobacco, this case involved a procedural due process challenge to a city ordinance banning the sale of tobacco products at certain establishments. The court found that the ordinance violated procedural due process because it didn't provide clear standards for enforcement and left too much discretion to city officials. These due process cases demonstrate that courts have generally been unreceptive to substantive due process challenges to flavored tobacco bans, finding that such bans are rationally related to legitimate government interests. However, we do have some instruction from the Indigo Room case out of Florida, reminding us to consider procedural due process standards as we craft flavor policies. We also have the takings clause of the Fifth Amendment, which prohibits government from taking private property for public use without just compensation. And that's been invoked here in some cases challenging flavored tobacco bans. Again, the RJR case versus the County of Los Angeles. In that case, tobacco companies argued that the county's ban on sale of flavored tobacco products constituted a regulatory taking of their property without just compensation. They claimed that the ban would destroy the value of their flavored product and packaging. However, the court rejected these arguments, finding that the ban was a valid exercise of the county's police power to protect public health and that it did not constitute a taking. We saw those same allegations in the National Association of Tobacco Outlets versus the City of Providence case. And then we saw it right here in the city of Moorhead, Minnesota. In Northland Vape Shop versus Moorhead, the business argued that the city's ban on the sale of flavored tobacco products constituted a taking of their property without just compensation. They claimed that the ban would destroy the value of their business. However, they settled out of court with a non-monetary settlement, just delaying the ban for 6 months. Courts have been reluctant to find that flavored tobacco bans constitute a regulatory taking under the Fifth Amendment, as long as the bans are justified by a legitimate public health rationale and don't completely destroy the value of the affected property. But it's not always just about the law, is it? non-legal lessons from cities that have implemented flavor bans. First of all, forging partnerships early in the process with local and national public health and advocacy organizations that have expertise in tobacco control policy and community engagement is so important. Secondly, engage community supporters, especially those most targeted by commercial tobacco, and support them in amplifying their voices. Third, seek legal technical assistance from organizations like the Public Health Law Center when developing policy language. And fourth, think about your implementation strategy, one that supports retailers and informs the community through an enforcement timeline. Bottom line, you may wonder, is this worth it? If you're a city attorney out there wondering, should I assist my client to do this, even if the political will is there to do it? We are here to tell you that you have the legal precedent behind you. Yes, we know that flavored tobacco bans have consistently been found to be a valid exercise of state and local power to protect public health, and we have a good body of legal precedent supporting it. But is it worth it? And to that, we also say yes, it's worth it. Here we have statistics from the Minnesota Department of Health, and that shows us that if we are going to draw the line on the vaping epidemic that's intruding our classrooms and schoolyards, then flavors is where it's at. The stats on this slide from the Minnesota Department of Health 2022 Minnesota Student Survey show us that we know that these ordinances are making an impact. And for those of you who've helped to achieve these policies in your jurisdiction, we say thank you. And for those who are perhaps interested in learning more, our door is always open here at the Public Health Law Center, and we would be pleased to talk with you. Here are some relevant resources prepared by the Public Health Law Center. You can go to our website to check out more information and data, both on the evidence supporting these bans and on the legal authorities. And here's how you can contact us if you should have questions. Thank you very much for your attention today. This concludes our presentation, and we open the floor now to questions and answers.
Great, thanks, Willow and Marissa. Great information. I just wanted to note that I did put into the chat links to the upcoming webinar in our webinar series regarding enforcement best practices. That will be on May 23rd. And then we also have a webinar that took place on March 27th that is archived, and that also has earned CLE credits. So you can earn on-demand CLE credits there. So we have a handful of questions. So I'll dive into the first question. So one of the questions we've had is, what if the legislature passes their flavor prohibition in state law? Then what happens with the communities, the 30 communities that already have their local laws? Willow, can you answer that question for us?
Yeah, that's a great question, and I love dreaming about it. If the state were to pass a comprehensive statewide flavor ban, what would happen to the other jurisdictions that have passed various restrictions? In a lot of ways, I think a great analogy to draw is that of Tobacco 21. So, for example, there were jurisdictions all throughout the state of Minnesota that had various age restrictions already requiring that you must be at least the age of 21 to purchase tobacco products. And then when the state passed its statewide ban, that still applied. So it applies equally throughout the state, but cities would still have the opportunity to be more restrictive if there were sort of exceptions carved out to the statewide ban. And for local jurisdictions that were less restrictive, they would have to step up then to the statewide standard.
Great, thanks for that. And the next question I have, I think, is for you, Marissa. So should communities wait to see what if Minnesota okay. Mixing up my question. So should communities wait? Should they hold off and wait to see what the legislature or the federal government do to regulate flavored tobacco products before they enact their own local flavor protections?
No, I don't think there's a good reason to wait. And I think, as you saw, in the past hour, that the trail has been blazed, in the sense of localities being able to enact flavor sales restrictions, and that, to the extent there's been industry challenge, the courts by and large are upholding these restrictions, and Minnesota is no different, as we saw with the city of Edina case. So I think, we went through the chronology. We've been waiting a long time. We've been waiting since 2009, since the passage of the Tobacco Control Act, to ban menthol, and certainly with all of the flavored e-cigarettes in the marketplace. Every day people are getting addicted. Every day people are getting sick. There's no time like the present to go ahead and work on an ordinance.
Great, thanks, Marissa. So we have one question in the Q&A. What about the challenge we're facing with the current policy? For example, they currently can sell, I'm assuming the retailers can currently sell the products, and now that we're modifying the ordinance, they can't sell it. Is there any argument that they are grandfathered in to be allowed to continue to sell flavored products, even if a new policy has been adopted?
Yeah, I mean, I think that goes to the heart of a lot of the legal challenges that the various shops in Minnesota brought, Arden Hills, Prior Lake, and Moorhead. And that we also just hear in city council meetings, even if there was no legal challenges, you have shops saying, this is a part of my business, and how can the government take that away from me? And that's where the litany of constitutional challenges come in, and that we try to unbundle all of those. But in legal terms, I think what those shops are saying is that this is a regulatory taking, that the government can't take this right from me without compensating me. They're saying that we're targeted differently. Why are they targeting tobacco shops and they're not taking away products from, other stores? And then they're also, so they're, wrapping in some due process claims, some regulatory takings claims, and then we see some First Amendment challenges get thrown into that too. So it's a great question. It's one that there's lots of challenges sort of bundled up into that. And my short response is that every time the courts have looked at this issue and picked it apart and analyzed it and sliced it and diced it from every direction, no matter how it stands, the public health interest or the governmental interest in the public health piece of this outweighs all of these other challenges. Now, that said, I would say, if you're dealing with a community where this is at play, work with the retailer. And the more that you can have a notice requirement, and that you can work with the retailer to give them time to retool, the more likely you would be to fend off any legal challenge like this. So the more you're able to give advance notice and be clear about what the definitions are, be very clear about what the public health rationale is, and provide timelines for enforcement, the stronger your policy will be to withstand any kind of argument like that. And thus far, we have a 100% success rate here in Minnesota.
Great, thanks for that, Willow. So one more question. Why wasn't menthol included in the earlier federal regulation of flavored tobacco? I mean, clearly menthol, mint, wintergreen are flavors. So why were those flavors given a pass?
Yeah, this goes back to what I had alluded to earlier, which was just, ultimately the power of the tobacco industry lobby, and really highlighting the critically important role that menthol plays in their profit shares. And they have been targeting certain communities, in particular the African American community, for many, many decades with menthol products. So that, and I think it was, just a situation, and it's really ultimately speaks to just the failure of the Tobacco Control Act. It was a piece of legislation that had huge potential to just remove all characterizing flavors from the marketplace in 2009 and failed to do so with that menthol carve out. And so, and I think it just boiled down to, being opportunistically exempted by Congress, and then they could punt it then to the Tobacco Products Scientific Advisory Committee. And what was frustrating about that, and it was so frustrating at the time for public health advocates, was that, this committee was tasked with studying the issue of menthol with evidence that's been available, that was already there at the time. It's not like they, did these studies and came up and found these findings on their own. The evidence was there. By 2009, everybody knew menthol was a problem. Everybody knew menthol was addicting populations, again, African-American populations in particular, sickening them, dying. And so it just speaks to, and here we are, in 2024, still pushing and still prodding the FDA to hopefully finalize this rule and to act on it, because it is way, way past due. For this rule to be finalized and implemented.
Good. Thank you, Marissa. So we have time for one more question, and I think this is actually going to dovetail nicely into our next webinar, which is about enforcement. So how do tobacco control organizers push back on retailers who skip around the local law, such as stores like who continue to sell flavored tobacco, even when the city ordinance says the products need to be sold at adult-only tobacco stores? So what if retailers continue to sell those flavored products? What can be done?
Yeah, that is a great question, and it does tee us up well for our final webinar. That is a trilogy of our Minnesota webinars about enforcement. And so that question in and of itself deserves about an hour-long response, but I can just briefly say that this question really emphasizes, again, the importance of local ordinances and local enforcement. We can't wait for the federal government to do something or the state to do something. The true power here is at the grassroots, because the jurisdictions do have the authority to do it. And locally, you have the relationships to be working with those who are enforcing these ordinances in a way that really doesn't exist to the same degree as it does at the state and federal level. And so if there's one thing to take away from this webinar, it's to say that the power here lies within the local municipalities, and we're here to support you in crafting those policies. We just encourage you to move forward where the law is strong and you have the political will to do so. Thank you.
Great, thanks, Willow. And I think for those of you who are seeking CLE credit, we can put the course number in the chat so that you can earn your credit. This webinar will also be archived on our website and will be available for on-demand CLE credit as well. So if you have colleagues that weren't able to attend today, they could still earn their CLE credit by viewing the recording and claiming the credit as an on-demand CLE. With that, thank you all for the great information today and for the excellent questions. And we will see you in May. Thanks.